My name is Jane Lee, and I'm the Director of the Financial Crime Resource Center, a program of the National Center for Victims of Crime. The Center for Victims of Crime is a national nonprofit established over 30 years ago, dedicated to advancing victims' rights and helping victims recover and rebuild their lives. We're pleased to present the Using Asset Forfeiture to Help Victims of Crime webinar, presented by Jennifer and Carly. Jen Bickford is an Assistant Deputy Chief in the Asset Forfeiture and Money Laundering Sections Policy and Unit, where she oversees the remission and restoration of forfeited funds to victims and transfer of funds to state and local law enforcement. Jen manages the activities of claim administrators retained in large-scale fraud cases and coordinates compliance of state and local law enforcement partners. She also provides advice, guidance, and training to the United States Attorney's Offices, federal seizing agencies, and state and local law enforcement regarding asset forfeiture policy, victim compensation practice, and the equitable sharing program. We also have Daryl Black. She is an attorney advisor in the Asset Forfeiture and Money Laundering Section Policy Training Unit, where she coordinates the remission and restoration of forfeited assets for the benefit of victims of crime, manages the sharing of certain forfeited assets with state local law enforcement, and also assists with the development of asset forfeiture policy. Carly serves as an AFMLS lead to appointed claims trustee in large-scale victim cases. Carly provides training to law enforcement agencies who participate in equitable sharing program, along with providing forfeiture and victim-related training to federal agencies. Without ado, Jennifer and Carly.
Thanks, Jane, and good afternoon to all of our attendees online and on the phone. I'd like to thank you for joining us today. We talk about using forfeit to help victims of crime quite frequently within our DOJ community, so we're very excited of having this opportunity to reach out beyond our forfeiture program and educate some of you in the field at local law enforcement or local victims groups or even the private sector about the ways forfeiture on the federal side can help your victims in your cases receive some compensation. The way this will work, we're going to go for about 25 minutes. Carly's going to be answering questions via the question pod all along, and we'll take a break if there's some questions that come in that make sense to address to the entire group, and we'll also leave time at the end for questions. So be sure to send those in to Carly. In addition, probably next week or so, you'll receive several handouts that go along with this presentation. One is the actual government regulations that rule this program and the way we are able to process funds to victims, as well as a sample petition for remission, which you'll learn about later on in the program, and a brochure about some of the victim compensation facts that our program is able to do. So we'll move forward here with our slideshow and get started. This is intended to be a very high-level intro to forfeiture and victims. Many of you who are on from our program have some information and knowledge of this, so bear with us because we're definitely trying to educate folks outside of our program about what forfeiture is and can do. This is public information. We post this on our DOJ website, but the scope of our program is huge. In the last 6 years alone, we've deposited over $1 billion into the DOJ forfeiture fund. The vast majority of those funds come from large white-collar crime cases. Madoff, you're probably familiar with, Enron, other large bank cases. Reading the news, the GM settlement and the Toyota settlement make up the majority of those funds that are deposited. And fortunately, through what we'll talk about later, we can actually use those funds to compensate victims of the very crimes underlying the case where money comes from. The only way that we are able to do this and get these huge amounts of victim compensation that you can see in our chart here is with the work of not only AFMLS, we come in at the end of the process, but the law enforcement, either federal or state and local, working these cases on the front end with cooperation from these victims who come forward. So it's very important to us that the victims have a say and a step early on and all the way through the process up where the U.S. Attorney's Office might be trying the criminal case against the defendant. We have some folks from the Marshals Service on, the Postal Service. I think even some of our Treasury partners are on in the attendance pool. So you will know that your assistance is obviously huge to this effort, and you work with victims on a day-to-day basis. For many of you wondering, Jane said we were from AFMLS or AFMLS. We're part of the criminal division. Carly and I are both attorneys in our office. we oversee and make policy for the entire asset forfeiture program. So if you're from a state or local office but working with the federal government on an asset forfeiture issue, those policies are promulgated from our office with input from the rest of our forfeiture community. The reason we're here today, that the main program you're interested in, is that we oversee the victim compensation program. Two methods that the federal government uses to get forfeiture funds back to victims are called remission and restoration. There's a long, hour-long or 2-hour-long class we could give on each one of those, but we'll touch quickly on what they are and how they work later on in the presentation. For those of you who are not familiar with just generally what's asset forfeiture, you may have in the press, in the media, there's a lot of state legislation, potential federal legislation touching on this right now. It has a very important purpose and can be used for a very good means to get these victims compensation. And what we talk about and what we mean by forfeiture is when the federal government takes property that was used in some manner contrary to the law. Either it itself, its proceeds, a great example is an embezzlement or securities fraud scheme where a victim might invest money to the scheme. That money that the criminal has taken from is proceeds, or use that money to go buy houses and cars and other things that we can also seize and forfeit and then return those proceeds back. Our primary goal here with this asset forfeiture program is law enforcement and deterring crime. We don't believe it appropriate that criminals should be able to keep the proceeds that they gain by committing crimes, especially when those proceeds came from victims. Our goal is to get those crimes prosecuted, forfeit assets, and put the money back in the hands of where it came from, the victim community. A couple different types of forfeiture. Nothing's ever easy with the law, so we have 3 ways that we can actually get assets forfeited. One is probably what everyone is most familiar with, a criminal case. U.S. versus John Smith is our example here. That's what the case name would look like if you were reading through paperwork about it. This is a case where we're actually trying the defendant, the criminal, him or herself, and along with that prosecution, forfeiting their assets. In those cases, we can only forfeit assets that belong to that very defendant, which is why number 2 on the list, civil forfeiture, is very important. These are cases, U.S. versus a house or a car or a sum of money, where for whatever reason we may not choose to prosecute someone. They may have fled the country or been a fugitive, but this allows us to recover proceeds from cases and assets that we do have a companion criminal case with. The third forfeiture on the list is administrative forfeiture. This type of forfeiture is done solely within a federal agency. The FBI, the Federal Bureau of Investigation, the Drug Enforcement Administration, the Alcohol, Tobacco, and Firearms, and our postal inspectors all have this authority on the DJ side to forfeit things within their agency. But to be very clear, before any of this happens, we have to have a showing that the property was related to a crime and that everyone with an interest was given notice and provided the opportunity to come forward. Once this happens and all of those steps are complete, the property is then forfeited to the government. It belongs to us, and we have the ability to choose how to distribute it among victims or other law enforcement programs. And we went through these types of forfeiture. Many of you might have wondered, why don't we need a criminal conviction? And there's a lot of reasons that I touched on briefly on the last slide, but some of our most important cases are where the defendants are fugitives. We have large-scale fraud schemes where the defendants are hiding in countries that will not extradite, and we don't think we should just leave their U.S. assets on the table for when they come back or to run and continue on their criminal organization. So civil and administrative forfeiture allow us to get to these assets and recover them for victims. A case you may have heard of, the Enron case. One of the defendants actually died prior to his sentence becoming final in the criminal case. Had we not had civil forfeiture, we would not have been able to gather his assets and forfeit them, and at the end of the day, provide them back to victims. So there's quite a lot of reasons that civil forfeiture serves a very important law enforcement and victim recovery tool in the box of tools that we have to find money and funds for victims. Many of you on the line are familiar with restitution. It's a concept that's much more widely known than our forfeiture and remission process. And if we don't have a criminal case, as many of you know, we don't have a restitution order. That's not a problem here for us. We don't have to have a restitution order to transfer funds back to victims. That's another reason we don't necessarily need that criminal case. And on the bottom of this slide is a website, forfeiture.gov. That's actually where we post notice of every ongoing forfeiture action so that anyone with an interest in those assets can come forward. I'll put a little caveat that generally victims, this is not the part of proceeding where they would come forward. We will work with them at the end of the case to determine how to get them back to them. This forfeiture.gov notice and notice of the ongoing seizure of the asset is generally meant for the owner or some of the lien holder interest in a house or a car to come forward at that time, because obviously if there is an innocent owner or a lien holder, they'd be able to come in and recap that property from us, and we would not forfeit it. There are many ways to forfeit. We just talked about civil, criminal, and administrative. There are also many reasons we can forfeit. And I touched on this briefly earlier, that if a defendant has the very money that he took from those victims, that would be proceeds of his crime. If you think in the context of a drug dealer, he may have a car or a house that he's selling the drugs from, or a Ponzi scheme promoter who's using his electronics equipment or his home to prepare false statements. Those assets would be considered facilitating property. He didn't earn them or buy them with what the victims provided to him, but he used them in furtherance of the crime. So you have the ability to get those assets for federal forfeiture as well. Other three blocks on the pyramid are larger in scope: laundering, racketeering, and corrupt organizations, and terrorism cases. In terrorism, the Patriot Act gave us wide authorities in taking assets from terrorists. Anything that they have, it does not have to be tied to the crime at all. So you can see on this slide the scope of what we were able to get to potentially give back to victims through our federal forfeiture process. Here's some just examples easily found on the internet of things that we do normally take in victim cases and other cases. Electronics equipment, cash, and vehicles are probably our most frequent assets that we see and are able to take from defendants. White criminals often have very nice real estate, jewelry, other high-end artwork, and assets that we can also seize and liquidate, working with our Marshals Service to get recovery for the victims from those type of assets. Obviously, weapons or other assets that implicate a public safety concern, we always take and forfeit those when there's an associated crime. And money orders. I saw some Postal Service employees on the attendance pod here, so you can certainly look to forfeit those when there's criminal activity associated with them. This sort of run-of-the-mill forfeiture case. What people don't often know is we extend well beyond the run-of-the-mill forfeiture case in the DOJ program. The slippers on the screen there are actually Madoff slippers. Normally, we would not take every asset down to the clothes from a defendant, but in this instance, he had very expensive wear, clothes, and other things that could actually be liquidated to recover funds that will be paid to the victims. There's some horses in the middle of your screen. Oftentimes, our Marshal Service will say, absolutely don't take animals. They cost an extraordinary amount of money and time to manage. But we had a case recently where over $10 million was recovered from a criminal who was running a horse farming and breeding scheme as she was stealing money to pay for it from her city. So we were able to make a significant recovery for victims in those type of cases. The slides in the far right, the dinosaur and the portrait, are cultural artifacts that have been returned to the country where they were stolen from or illegally exported from. So our program extends widely to international and domestic crime and has the ability to get back property to victims, both currency and money, and compensate them that way, or if they're actual items stolen from them, especially from a foreign government, an item of cultural significance, our program allows us to get those assets back to where they belong. Here's a quick diagram of how our process works. We have our victim on the top who unfortunately gives wrongdoer money or property. That's a scheme, unfortunately, that we see happening all too often these days. But when that wrongdoer receives the funds, they now have tainted assets. They use them, they spend them, they buy other things. At this point, our Marshal Service, the FBI, U.S. Attorney's Office comes in and they're investigating and making a case, and making enough of a case to prosecute and indict and convict that defendant is not the only step. Our agents and our attorneys are trained to look for assets that can be traced back to the crime to potentially be returned to the victims at the end of the case. So they're working on all of those things simultaneously because we have found that our forfeiture tools are much stronger at the front end of a case before the defendant is able to hide and liquidate his funds and wait until that restitution order might be entered. This slide that comes up next here shows you a little bit about restitution and forfeiture. They're very, very complementary. Many people, like we said, only have ever heard about restitution, and this forfeiture and victim compensation is brand new to you. They overlap very closely. They have the same goals, getting money back to victims at the end of a case. But like I mentioned, our tools in forfeiture on the front end can be used for certain assets, whereas the financial litigation and recovery units at the federal government are often used afterwards when a case is over, and at that point it might be too late to find a lot of the assets that the defendant had taken from the victims. Very clearly, and you can read this on your own as well later, but there are some differences, and the most important one is really the ability for us early on with forfeiture to see or restrain the assets. If we don't do that, we have found in case after case, if we simply wait until the end, that restitution order and the judgment for the defendant to pay that victim back will never be satisfied because they've hidden or liquidated or passed off their assets to others, and it's too late at that point to try and track them down. Those have a little bit different mechanisms of enforcement, all of the federal government, the agencies, and the U.S. attorneys working hand in hand, but they do have very separate tools, but the same goal at the end of the day, to get money back to the victims. And to go through who we're talking about here, you do have to be a victim of the federal crime for which there was a forfeiture. NCVC and I know the Crime Victims Fund that's within the DOJ use funding to pay for grants and larger nationwide programs. The unique thing about our forfeiture program is that the funds that are forfeited in a case go back to the very victims of that crime. So we don't have just a large pool of money to spread around the country. We're looking specifically at the case that you're associated with. We do not require there be a restitution order or even a criminal conviction as long as we have a forfeiture of proceeds of those crimes. And when you think about victims, most people think an individual, a large pool of people who might have invested or been convinced to send money on Craigslist or eBay, or an employee at their company stole their money and embezzled. That is certainly a large class of what we see. More frequently, though, we are now seeing federal, state, and local governmental entities victims. And at the end of the day, when someone conducts healthcare fraud or food stamp fraud, you and I are the victims of that. It's taxpayer-funded programs that people are defrauding. So we treat federal and state and local government entities as victims in our cases. Foreign countries have also been victims when they've had money embezzled that we have located and forfeited domestically. So you don't have to be a person to receive forfeiture if you're a victim of a crime. It extends well beyond that in our program. Type of losses that we will compensate differ slightly from those that can be compensated under the restitution rules and grants that a lot of programs may provide for medical bills and counseling. Those aren't the type of losses that we compensate with the forfeiture funds. We're looking at the direct losses that the victim incurred. So if you invested in Bernie Madoff's fraud scheme, your investment in would be your loss. If you had taken money out during the time of that fraud, that's credited against your original investment. So we're looking to get a net loss figure for our victims, and that makes it very equal across the board, that we treat all victims the same. We don't pay attorney's fees. We don't believe it appropriate to elevate one attorney's loss to a much higher level, victim's loss to a higher level because they've hired an attorney when they've invested the same amount with the defendant. So we try to keep our victims on the same playing field. We don't permit victims with judgments to come in over victims who do not have judgments. The only way a judgment creditor would take priority is if they had actually perfected that judgment against the very property that we had forfeited. This, again, help serve that all victims, whether or not they can afford an attorney or have to go to court, are treated fairly when we go to distribute the assets at the end of our case. One sort of caveat to that pecuniary loss policy is recently Congress enacted the Compensation and Restitution for Trafficking Victims Act. This has allowed us, in cases of trafficking, to actually transfer funds to court to pay to these type of victims. When you think of these typically young girls being trafficked into the country, forced into prostitution or other jobs that don't pay them any money, they're horrible, very sympathetic situation. Our regulations just did not permit recovery of funds to them for medical bills and the counseling we all know that they need. So this provision that was enacted last year allows us to transfer some of our forfeited funds to this type of victim. And as most recently as in December, when the Consolidated Budget Act was passed, there's a new fund for victims of state-sponsored terrorism. These are entities who were significantly injured in bombings or terrorist attacks with nexus to the United States. There's a new fund that will be filled with funding from the forfeiture program to pay judgment holders of some of these horrible terrorist acts. So our program is evolving, and Congress is helping us get there by allowing us to transfer funds to some of these type of victims who don't currently meet our regulations. And here's a few takeaways really quickly before we stop for some questions. If you are a federal prosecutor, you probably are already doing this, state and local prosecutors as well. But if you're with a private entity, a victims group, these are some things that you can do to make sure your victims are heard. Obviously, we want them to report the crime to law enforcement. We know, and we've talked to victims who are often embarrassed or don't want to admit that they are a victim for any number of reasons. If they don't come forward, fortunately, we don't know about them, and they will not be able to participate in any recovery because we don't sort of send money out to people we think victims. We do have a process to report to us, so they do have to come forward. And any kind of cooperation that they can provide during the case to the agency investigating that case or the prosecutor working that case, either federal, state, or local, information can help make the case stronger against the defendant and allow us to potentially find more assets or get more charges that then tie back to their crime and allow them to get money from our forfeiture program. In addition, if they have documentation about their victimization, that's also very important. Our regulations require that a victim provide documentation of their loss. So those bank statements and checks that people sometimes throw away many years later, if you're talking to them early on, help them to preserve those so that they have them to work with the Federal Bureau of Investigation or DA on a case that might be the evidence that's needed to take that case forward. I'll stop here briefly. If Carly has any questions that came in that are germane to the entire group, we'll answer some of those now.
We have one question, I think, regarding kind of jurisdiction. Someone from the Virgin Islands is asking to what extent their victims can participate in this process.
So the question, if it didn't come through, was to what extent jurisdictionally can victims participate in the process? And we have no boundaries. We're working on some cases where all of the victims are international victims. They don't have to be U.S. citizens. They don't have to live or ever have lived here in the United States. If they are a victim of the crime that we are federally prosecuting here and we get assets, they will be eligible potentially for a share of those. So we don't require that this process is only limited to U.S. citizens.
And we have one more question. What states are you aware of that are using similar procedures under their state law?
The states have very different forfeiture and fund disbursement hierarchies, both on the victim side and on the law enforcement support side, so I don't want to opine on what a specific state may do. That's not our area of expertise. If there are certain states that you're interested in, definitely send a question in the question pod and we can get you in touch either with a federal prosecutor there who may know or someone on the state side, as we have a lot of state prosecutors who we regularly correspond with.
One popped up, Georgia. Georgia does this.
Yes, I know we have a very strong law enforcement community coordinator in Georgia, so we can reach back out to you with the attendance list there. If there's any other large questions for the group, one more.
One more. The question is, what is the average payout to a trafficking victim?
It's it's very hard to put averages on our cases because it depends on what we are able to find and bring in. Unfortunately, in a lot of our cases, we never recover 100% of the proceeds. The defendant has spent money in ways that we will never recover on intangibles, or they have hidden it or passed it off to people that we can never find. So in most cases, 10 or 20% on the dollar recovery is high. We do have a case where we are doing close to a 90% recovery, and I have seen some with 100%. In the trafficking context, because it's so new and that legislation just passed last year, it remains to be seen, what kind of assets they're going to be able to locate from the people running the trafficking ring. And a lot of those assets are oftentimes held overseas, and we don't have access to them unless we find them and can get them into our jurisdiction. So it's hard to say in a specific type of case, especially what a percentage might be. Unfortunately, it's not high enough. In our opinion, we should be able to make these victims whole, but defendants have ways of hiding and spending their money that we are never able to recover to make someone financially whole. So we will do questions again at the end, so definitely keep them coming. We'll spend the latter half of the presentation here talking about exactly what our process is. Now that we've learned very briefly about forfeiture, very high level, we'll talk about what we do on our end to actually transfer these funds back to the victims and what you can share with victims so that they know what this process is going to be like. We have folks often ask us, is this a scam? You're sending us these forms. No, it's a scam. If it has our office, you're always free to call and ask, but there are paperwork requirements that do go back and forth, as with anything in life, that the victim will need to complete. The first way we are able to transfer funds to victims is our process called remission. In this process, you don't have to have a restitution order, we mentioned earlier. We don't have to have a criminal case. We simply have civilly forfeited assets that we're able to identify were related to the crime, and the victim has identified that they are indeed a victim of crime. A great example here is in the Bernie Madoff case. Most of the money that the government is currently holding, about $4 billion, was civilly forfeited. Yes, Madoff was tried and is doing a essentially life sentence in prison. The reason we have those forfeiture funds are from some settlements with the bank and other families of investors who received large proceeds as a result of his scheme. In this instance, if you invested in Madoff, we have a process where you can submit a petition for remission to us that will be evaluated. We do this in the largest of large cases like Madoff and very small cases with low dollar amounts seized and one victim. Every case is very important to us, and the process is run the same way, whether you have tens of thousands or 100,000 victims or one. So we require, and I believe one of our handouts will be a sample petition for remission that you can look at. It's going to be slide here as well. That is not a specific template. We don't require any specific format, but the U.S. Attorney's Office will send notice to victims who are possibly associated with this crime. In some instances, the FBI or DEA may also send that notice. The format of the petition is not standardized. We have the template, it's just that, but a petition can be a letter. We joke that you can write something on a napkin and send it in, as long as they can convey their information to us and provide appropriate documentation so we can figure out who they are, and that they are indeed a victim of the crime. We will consider that a petition. Once it comes to us, the victim will likely be contacted by FBI or the DEA as they're investigating the merits of what was said. Unfortunately, as with every program, both private and government, people try and take advantage. So we have had cases where fraudulent petitions have come in, and were we to not do our due diligence and investigate all petitions, we run the risk of potentially sending money to a fraudulent petition that would therefore dilute the money available for the actual victims of that case. We take our duties very seriously in looking at all of the paperwork and the petitions that come into us to make sure we're getting everybody back the most possible. We're here in D.C., so we're not out on the scene looking into or doing any of the investigation. We rely very heavily on our local U.S. Attorney's Office and federal seizing agency to be doing this investigation and making us recommendations. We don't have staff or personnel to do that ourselves, nor would we want to, because we are not close to the case. these victims are oftentimes already talking to the very people that are going to be doing the petition recommendation, and we want to continue that dialogue because they're in the best position to move that process forward. Sample templates is on our website, which we'll provide you later. The majority of petitions that come in, like I said, do not come on this form. The key takeaway, though, is that the victim identifies their case and provides us some kind of documentation or information so we can link them back to that crime. The process that we use, which is easier, more efficient, and takes the burden off of the victim in some respects, is the restoration process. What AFMLS has done over the past several years is essentially take a step back and say, in the remission process, we're asking a victim to send us paperwork about a crime where they've already been victimized. They may already have been talking to the U.S. Attorney's Office, and in cases, we have an ongoing criminal case with a restitution order entered. And to get that restitution order entered, the victim likely filed a victim impact statement, may have appeared at sentencing, spoken for the court, and somehow came up with a figure that was determined to be their loss that a judge agreed with and put in a restitution order. It was not efficient and didn't make any sense, and quite frankly, was a burden to the petitioner to do that all over again by filing a remission petition. So what we have done at our office is to permit essentially the U.S. Attorney's Office to file a request with AFMLS that we transfer our forfeited funds to the clerk of court. Once that happens, they're distributed via the restitution process. So the victim is not required to come forward again. We put burden on our federal government, U.S. Attorney's Office, seizing agency, and AFMLS to review what was done as part of the court process. The past 2 to 3 years, restorations have become much more frequent, being sent to our office from a U.S. Attorney's Office than remission. This is the preferred way to go if we have a criminal case and a restitution order. Where we don't see restoration are our large, very, very large, multi-tens of thousands of victim case where we have to actually hire an outside contractor to process remission petitions. The judge and our office, the U.S. Attorney's Office, know is equipped to potentially send notice to 1 million people and then review the 100,000 petitions that might come in. If that were the process we use, these victims wouldn't see money for years. So they're able to, through a contract we have in the government, hire a claims administrator who is a third party who will step in and provide notice and process that remission payment through the third party contract. That's the one case now where we see remission being used still very heavily and more frequently is in massive large-scale fraud schemes. For the most part, though, restoration is the trend that we're seeing around the country. And this is due in part to, in a lot of criminal cases where we do forfeitures, there is both a criminal case and potentially a civil case ongoing. We are using to prosecute the fraudsters, the embezzlers, and the other theft defendants who are committing theft to make sure we can convict them and also get restitution orders and get money back to their victims. As you can see, this slide has less arrows on it because it's a less burdensome process. The victim filing something is removed so that that burden is gone, as I mentioned, and the U.S. Attorney's Office submits that request to us. These two icons on here don't adequately convey all of the work that obviously has to go on behind the scenes with the judge and probation and the agency, a lot of moving parts to get that restitution order entered. And our U.S. attorneys who are responsible for collecting on that order on the back end also have a role in this. So there's quite a lot of moving parts, but at the end of the day, for the victim, this is an easy process. The U.S. attorney, though, does have to request it. A victim can't come to us and say, I would like to request restoration. That's a decision and determination that will be left up to the department. And in some instances, separate from the very large cases, we may not be able to grant or approve restoration, and we may opt for the remission route. So the victim can always file remission. They can't ask for restoration. This is something that we initiate as the federal government. And we'll do a quick takeaway here on the second half of the presentation. And we went, I know, very fast through the two types of mechanisms. One was remission, where our victim files a petition. The other, restoration, where we work in tandem with the clerk of the court to send me out through the restitution process. For those of you who interact with the victims, some things that you can do to ensure these compensation processes move smoothly is just learn about our process. If you know what both are and how they work, at least at a basic level, you can provide some guidance to the victims as, let's go ahead and file a petition now, or, maybe we'll talk to the U.S. Attorney's Office and see if they're planning on doing a restoration. We won't have to burden you. So definitely want to be engaged early on and serve as a liaison between your victim and the police agent or the agency in the U.S. Attorney's Office to work towards the best efficient end to get them their funds. So to highlight is DOJ's forfeiture program is not the only government program that provides compensation to victims. The SEC in large-scale securities fraud cases oftentimes point fevers and has funding available to pay. In those cases, the FTC, the CFPB, and some others run victim compensation programs. We'll see here in a few seconds, we'll go through some notable cases that we have that highlight the way we cooperate with these entities, and you may recognize that as a possibility case. We're happy to hear about that, and if your victim has already filed something with SEC, we may be able to use that documentation on DOJ side for any number of reasons. So definitely educating yourself about how these processes work and that they even exist, and we have the ability to work with other federal government entities is definitely a huge advantage if you're working with some victims. The note on here is communicate with probation. If we have a criminal case going, they are often, especially defendants cooperating, want to pay their forfeiture and restitution to get those off of their books. And sometimes they are required to meet terms of the probation to be making monthly payments. So you certainly can reach out to those entities to assist if you know of assets. The Marshal Service has investigators who, of their time, look for assets that can be used to satisfy victim compensation on the DOJ side. So definitely, if you find assets, even better, let us know. But there's a lot of ways that you can work and help your victim make sure that we are able to satisfactorily compensate them at the end of one of our fraud cases. Stop here for a second before we talk about some of our cases to make sure we've addressed questions that came in.
All right. One question is, how do we liquidate tangible items?
Great question. The question was, how do we liquidate tangible items? And I know on the attendance list we had quite a few folks from the U.S. Marshal Service. On the Department of Justice side, if we seize and forfeit a house, a car, a horse, anything tangible, our Marshal Service works to liquidate those assets. So they enter into contracts to sell real estate, to sell jewelry, and then once those assets are liquidated, we obviously have some costs in liquidation that are recovered first. The balance of those funds are put into our forfeiture fund and made available for victim compensation just in the same way that cash or bank accounts that were seized are available.
Okay. This is a question about the difference between what you can request via restitution and what you can petition for. So are restrictions on what a human trafficking victim can request for restitution, are they limited to just the assets that are forfeited from the defendant?
So in any case, not just human trafficking, the funds that we will use to either pay the victim directly through remission or else transfer to the clerk of the court only come from the very case in which they were victimized. So we have a large pot of money in Madoff that will be going to the people in Madoff. Even if we have a smaller amount of money in one embezzlement case or one trafficking case, that smaller amount is all that's available in those cases. So we tie it directly to the crime from which it came when we're talking about how to distribute out.
The restitution order itself can be higher than what we actually have on hand.
The restitution order can be entered any figure that the clerk deems appropriate and the court decides to sign off on. And in many cases, unfortunately, it is much higher than what we have available through the forfeited proceeds. So what happens is we will send our funding to the clerk of the court from our forfeiture case. They will pay it. The defendant still will have the remaining restitution balance on the books that he may pay, he or she may pay, or our financial litigation units may find wages to garnish or other assets to attach after the case is done, but it's very frequent that the restitution order is a higher figure than the money we have available through the forfeiture program.
If a local prosecutor in Virginia prosecuted a non-federal case and the crime is a violent crime, how would a potential federal case affect them, a federal forfeiture case?
If we have, I think the question is asking if a state has happened to a crime that's connected with a potential federal case, how would the victims interplay there? And the answer is we have to have a federal case that's to a federal forfeiture. If there's also a state case going on, that's great. It doesn't affect our ability to potentially pay funds out to the victims. In fact, we've worked in the past with state AG's offices who've received like their business bureau complaints and were doing their own investigations of some large-scale companies and share with us their victim information so we can be sure to notify those same victims in our federal case. The only exception would be if a victim somehow recovered their full losses through a state case, they would no longer have a loss and would be eligible to get funds from our federal forfeiture program. But we're absolutely willing and more than happy to work with state AG's offices or state prosecutors to the extent that we have complementary cases going on and the same victim pool potentially coming out at the end of the case.
One question that is more to the federal audience. Within the government, how does the Financial Litigation Unit find out about the U.S. Attorney's Office's recommendation and pending petitions? And basically, how does the FLU find out about remission and restoration cases?
So the question really gets to the heart of how do we let people know that we're doing this and that we're providing forfeited funds back to victims, because different entities have different responsibilities in collecting on the federal government side. So generally it really comes down to communication, both within the U.S. Attorney's Office, if there are state actions going on between the U.S. Attorney and that state and local day, the agency, our Marshal Service, making sure that everyone is talking and communicating, we find leads to the best result in these cases, because we're working early on to seize and restrain our assets, especially if we get information from a state matter that is allowing us to identify victims early. We can loop that information in. Then the U.S. Attorney's Office, the forfeiture attorneys, the criminal attorneys, and the Financial Litigation Unit attorneys should be talking with one another to make sure that we're not double working. Everyone has different types of assets that they can look for in different roles in the process. So we want to make sure that everyone is aware of what, at the end of the day, we are able through forfeiture to provide to victims, so we're not providing double effort for the same recovery. We'll take one more, and then we'll go to our notable cases.
Okay, I think this last question is basically the same one that you already answered with how parallel state and federal forfeitures, and what happens if they're related or not related.
And it was the question is again about a state case, a federal case, and I talked a little bit about it with a couple questions ago. One other point I will add, though, is a state restitution order is different than a federal restitution order, and we are not able to send our funds to a state court. However, the victim who might be listed in that state restitution order, if we are doing a federal crime related to the same victimization, they would be able to petition in our case. We've also worked with international governments outside of the U.S. on their victim list. So we definitely want to make sure that we have everyone talking and the victim groups are coming together to make sure that everyone's identified, give opportunity, and we'll figure out through consultations with the U.S. attorneys to a federal case what path and what course of action makes the most sense going forward. We have about 15 minutes left, so we're just going to take some time. These are cases you may have heard about in the news, so you can see sort of the scope and breadth of our program and the type of cases that we do. These are all very high-dollar, high-profile cases, but I do want to highlight again, we do one victim, one crime. I think we had a case the other day where we approved about $1,000 to go back to a victim. So we don't discriminate based on size of your case or type of victimization. We do everything that comes to us through our federal system. But these are some examples just so you can see what's going on out there currently in the victim world. U.S. versus Madoff, I've mentioned a couple of times already. We're actually running a website, MadoffVictimFund.com, which was posted earlier in the presentation. 65,000 plus people have filed a remission petition. The vast majority of these people did not see a penny from the complimentary civic proceeding that's going on because they were not a direct customer of Madoff. They invested through some other fund, which was the way most of the investments ended up getting to Madoff. We're currently reviewing these petitions, and we have about $4 billion on hand right now that will be distributed. Unfortunately, the losses everyone has seen in the news, and most recently with the mini-series that was on, this has picked up some more inquiries to our office. The losses are far in excess of that. So we will be paying a portion back to these victims, but for the first time in a lot of years, they will be able to see some recovery as a result of crimes that Madoff committed. Another case that wrapped up in the last few years, if you are from Florida or the South, you may have heard of U.S. versus Rothstein. We have about $26 million in this case. And the reason we're highlighting it here is we were able to work with both the bankruptcy matter and a forfeiture matter to get the best result for victims. There were 10 cases going on, and we like to leverage assistance in any forum that we have. So if the bankruptcy trustee is already notifying victims, trying to figure out their losses, there's no reason that we at the DOJ have to duplicate that for our program. So we are often able to work hand in hand with ongoing practices in bankruptcy or with another federal entity to get these funds back to victims. And in this case, the victims receive near full recovery. It's a little bit older case, but it's one of the first large-scale Ponzi schemes, probably about 9 or 10 years ago, that we saw that involved significant funds, large real estate in Colorado, and we did recover quite a bit of money to get back to the victims. This case was one that triggered our realization that we needed to hire external resources to run these cases. It's an unfortunate reality that these Ponzi scheme cases are only becoming more frequent and more expansive, more victims, more money, and we don't have the resources in-house or our U.S. attorney's offices or our agencies to process this volume. This case took some amount of time to get victim recovery. Not the right answer at the end, but it highlighted that there is a growing crime, white-collar fraud program that we needed to put in place to make sure these victims can get recovery in a timely manner. This is an ongoing case. A lot of times the department will file charges against a large corporation and then also have a forfeiture component as part of that. MoneyGram was recently charged with aiding and abetting a lot of its agents who were conducting some of the worst kinds of fraud, elderly fraud, grandparent schemes, phishing schemes to buy things on Craigslist and then require that you send the money through MoneyGram. Their agents were doing this, getting bonuses, and so MoneyGram, as part of a global settlement, forfeited $100 million. We're able to pay out over $6 million of that to victims who came forward, in part because we worked with the FTC on a prior case where they had paid some MoneyGram victims, and heavy input came to us from the state AG's office on this case because they had also been working up victim lists of potential MoneyGram agents that were defrauding their customers. This is a little bit older, but one of our first high-dollar, $728 million victim recovery cases where we were able to pay 8,000-plus victims who had stock in a company that went bankrupt as a result of fraud. We're seeing this more and more, these white-collar fraud cases. I believe Enron may be the next slide. On here is a more recent one. I mentioned earlier we used both criminal and civil forfeiture successfully in this case because of circumstances surrounding the death of one of the defendants. We also coordinated with the SEC. In this case, we did not have to hire our own external claims administrator because the SEC had already done that. And then we like to leverage other things out there that are already ongoing to compensate victims. So we worked with the SEC administrator to give him $100 million to add to the funds that he had already collected. And in this case, 128,000 victims were receiving recovery. So you could imagine if we had required the SEC to complete and conclude their victim process and then ask all 128,000 victims to again file a petition with us is just duplicative, and the only person at the end of the day who's hurt by that is the victim because they're reliving the crime and giving, the big government as a whole the same documentation over and over again. So our goal at DOJ is to get victims their funds as efficiently and quickly as possible, even if it means turning our funds over to another government entity who's administering a victim compensation program. This case I mentioned earlier, it hasn't received as much nationwide notoriety, but it's a very good example of how working with our U.S. Marshals Service, our FBI, and our U.S. Attorney's Office early on in the case in a successful recovery of I think it's actually up closer to 10 now as additional assets are coming in, $1 million returned back to the city. This woman had embezzled money from her city. She was a comptroller and her own horse breeding operation. So most of her assets, as you might imagine, were kept in horses and farms and things associated with that. So without the close coordination between our federal partners, taking and seizing and forfeiting assets, animals, and horses would normally be a losing venture. But here we were able to successfully recover quite a bit of money for this town through the efforts of the federal government. And the town that I mentioned earlier can be a victim. It doesn't have to be an individual. So here's an example of a case where a governmental entity was recovering funds, and the people that lived in the city of Dixon are able to now get some public services back that they had cut due to budget cuts because it was embezzling such significant sums.
Jason Woodillo weighed in and said $10.3 million to date.
Oh, so we had a comment came in. The lead marshal on this case is actually watching the presentation today. This is old hat for him, but he just noted that we have over $10.3 million and still going. And this ties back to what we were saying about if you're in the private sector or a victim advocate, keeping in contact with the Marshal Service, the agencies, as you've been working with them all along. If you learn of other assets, we are always happy, assuming we can tie them back to the crime or in some way liquidate them if they are related to the forfeiture, we're able to do supplemental payments to victims. So it doesn't necessarily end the day we make a payment, especially if there are assets that are hidden elsewhere. We oftentimes get tips and information that lead us to future recoveries. So make sure your victims are aware of the process when it's happening, but also willing and able to share information that can help us do additional recoveries coming in many of our federal cases. This is an ongoing matter still. Many victims have received payment. I believe we're actually up to 95 or 100 million to 30,000, 40,000 victims who had money in an online poker site that crashed and was prosecuted for lawful gambling activities and fraud because they had cut all of their player money. So there was nothing available when the company was taken down to pay all of the poker players who had accounts on site. So we put the case in here because it's a little bit different than what you think of as a victim of a crime. I think one jumps to white-collar crime or trafficking or crimes like that where it paints a picture of an embezzlement, but this is a little bit different where they were only turning over their money, playing poker, and little did they know that the company had no assets on hand. So we're still working through some remaining petitions in this case. At the end of the day, over $100 million will have gone out to compensate a very, very large number of victims in this case. Very quickly, because we have about 5 minutes left, slide here with 2 resources that we have publicly available on our website, which you can see there. There's a brochure that will also be a handout to the presentation that will come from NCVC later on that talks about what remission and restoration are, so you can educate yourself and your victims about those processes. And also our DOJ asset forfeiture website has a lot of information about our victim program. And what I would like to point out on there is a link to our ongoing large-scale fraud matters where we have hired a third party. Any of these cases, our third-party contractor is the one mailing notification, mailing checks, and corresponding with the victims. And we frequently get questions asking, is this company name fraudulent? Is this a real DOJ program? So we make sure to put a link to all of the ongoing processes that our claims administrators are running so everyone can go and check and say, this is the company I heard from, this is the ongoing process, it appears to be legitimate. We've had banks call us when victims have showed up with checks, and we've been able to verify those checks because we've seen, unfortunately, once a victim, sometimes the victim is victimized again, and banks are doing some due diligence to make sure that's not happening. We're happy to take those calls. We want everyone to be comfortable that when they're dealing with a third-party contractor, it is a legitimate DOJ case, DOJ disbursement coming their way, but here's a first stop for you to go to. If you're looking up a specific case, you can go right to our website and see what's on there. And our next slide, I believe, just has some contact information. Our main office phone number is on there. Carly and I and some other attorneys at our office are happy to answer any questions at all about our victim compensation program. And we have time right here for probably one or two more questions that came in from the question pod.
Yeah, we have a few more.
Hello? Slide, please.
Oh, yep.
Thank you much. Before we answer the last few questions, just want to let everybody know we have been approved for CPE credit. To obtain that, please email me at jlee@ncvc.org, and I will provide you a certificate of completion. Okay, thank you.
Thank you, Jane.
Excellent. Thanks, Jane. Question. This is a really nuanced question. What happens if the bankruptcy trustee's claim priority list conflicts with the restitution order?
So we have, someone has clearly dealt in this world before that bankruptcy trustees have statutory obligations to prioritize their claimants in one way, whereas a restitution order might have a very different prioritization of victims. So the short answer is sometimes it's more complicated, and we can't just say, bankruptcy trustee, take all of our funds, because they may be paying creditors as opposed to the actual victims who we choose to pay, which might have been the underlying company stockholders if this was a bankruptcy for a company. And in those instances, we would not be able to work as closely with the bankruptcy trustee. We would have to do our own process and figure out who our shareholder victims are as opposed to the creditor victims for a company. So to the extent a bankruptcy trustee or an SEC trustee or some other outside entity from DOJ, class action administrators even have worked with us to the extent that their list matches with ours or is substantially the same as what we consider the victim pool, then we are able to work closely with them. So that was a great question and highlights a point that we do have to make sure that the victims that those other entities are dealing with are our victim pool as well.
This is a question that might require some speculation. How should the attendees figure out the contacts for their state forfeitures?
No, I would recommend if you're looking for information on your state forfeitures, probably the best place to reach out to is your state AG's office to see if they can put you in contact with their forfeiture folks, or else a local district attorney or a local prosecutor should know their state forfeiture rules. I would reach out to that type of entity as well.
And one more question about the Crundwell horses. How did we account for the health and the well-being of the horses taken into custody, and even say the dogs in the Michael Vick case?
Yep, the question is about specifically in the Crundwell case that we mentioned where she embezzled from her town. How do we manage, $1 million worth of horses? Or we had also several years ago forfeited dogs in the Michael Vick case. How do we manage those animals? Our Marshal Service, doesn't run shelters or zoos, but they are positioned to be able to find veterinarians and people to manage assets, and they have authority to work with those entities to make sure over the course of a case there were horses that were born and horses that were died because the case has been going on for a while, and we need to make sure that they're being taken care of appropriately. So the Marshal Service coordinates all that. While they may not do it themselves, we take funding then that's ultimately resulted from the sale of those horses to fund those contracts. The veterinary bills, the stable bills, the feed bills add up very, very quickly. So that's why we recommend if you do cases with animals, anything alive that needs significant care, definitely make sure that your Marshal Service is involved in that. We had snakes recently that were held at a zoo is how the Marshal Service ended up resolving that issue, because they certainly don't want to keep snakes in a tank in their local district office. So any kind of asset that breathes, definitely call your Marshal Service, but even ones that don't, complex holdings of businesses and stock, our Marshal Service are well equipped and trained to handle liquidity of these assets the most efficient way to ensure that we get recovery for victims at the highest amount possible at the ends of these cases. So I see that it has hit 3 o'clock. Like I said, Carly and I are both happy to take questions at our office via email or phone. We hope you found this instructive. It was a very short amount of time to give you a lot of information. We often train these topics in several hour or several day training blocks, so you've gotten a very high-level overview of both forfeiture and our victim program here in this last hour. So don't be shy sending us questions. At the end of the day, all of us in this for the same reason, and it's to make sure our victims get compensation no matter what the crime, and we want to do that in the best and most efficient way possible. So thank you very much for your attendance today, and look for those handouts coming to you in the next week or so.
Thank you so much, Jennifer and Carly. I personally learned a lot as well, and it's a wonderful presentation. As Jennifer mentioned, we will be sending an email within a week with the handouts mentioned by Jennifer, attaching also a recording and a copy of the PowerPoint slides. Again, you can email me at any time at jlee@ncvc.org for CPE credit. And thank you very much for attending.